My name is Mary Adkins, and I'm interviewing you, Justice Ben Overton, as a part of a project for the Florida Supreme Court Historical Society. Justice Overton received his BS, BA, and JD degrees from the University of Florida, and also received an LLM in jurisprudence from the University of Virginia. He served as a circuit judge for 10 years and was the chair of the Conference of Circuit Judges at the time that merit selection of appellate judges was adopted. Justice Overton was the first Florida Supreme Court justice selected under the merit selection system in 1974 and served as Chief Justice from 1976 to 78, very early in his tenure. Justice, how did it happen that you became Chief Justice so soon after getting on the court?
Well, there was a major change that occurred at the court. Actually, there were 4 of us that came on the court in a 14-month period. I was appointed in March of 1974. Justice England came on in January of 75. Justice Sundberg came on in May of 75. And Justice Hatchett came on in July of 75. And the law clerks, all of us were in our 40s. The law clerks called us the young bucks. The general rule, not written, on the Chief Justice was that the justice that had not been Chief Justice in seniority would be selected. At that particular time, the justice that would be in that category had been charged by the Judicial Qualifications Commission. So basically, I was the next in seniority, and I was selected as Chief Justice as the law clerk said, the chief of the young bucks.
Okay.
I was the oldest. All of us were in our 40s, and the 4 of us brought 14 children to Tallahassee.
Good heavens. So you were the oldest of the young bucks.
The oldest of the young bucks.
And just so that I understand correctly, so the person who had the most seniority, who had not yet been Chief Justice, was charged by the JQC, was being investigated then for misdeeds, is that correct?
Correct.
Okay. Let's talk a little bit about merit selection of judges. Do you think that the fact that that judge had been elected and the rest of you had been selected had anything to do with the sequence of events there in the middle 70s on the court?
Well, I don't think it was so much that, but it was in a matter that how they were elected back then is that you qualified, and if there were vacant seats available, you all were on the ballot. And for instance, there were 3 seats available. And I believe there were 8 candidates. The more interesting thing about it, the ones that won were the top 3 on the ballot, what they call the ABC. Justice Atkins, Justice Boyd, and Justice Carlton were the top 3, and they were the ones on the ballot, and they were the ones that were selected. Of course, the issue concerning a competitive election of judges was not how this country started. One of the things that would be most unusual that the Founding Fathers would have judges that were subject to the competitive process and a competitive election. Hamilton wrote about it in the papers, the Federalist Papers, and how important it was that the judiciary be separate from the political process. That was the reason for the lifetime appointment of the federal judiciary. And for the most part, that was not unique, because almost all the judges in the states at that time also were not subject to a political election. The political election did not occur until the late 1830s in the Jacksonian era, and where they were looking for patronage. It evolved where there was a conference in the early 1900s that there was a discontent with the judiciary generally. And it was a result of that conference that the merit selection, merit retention program was initiated and written about, which got its name from as the Missouri Plan, because Missouri was the first to adopt it. It basically is a compromise from the lifetime appointment to the appointment by on a merit basis, and that it does not require a competitive election, but it does require the people to say, should this judge or justice be retained?
So merit selection and retention then is not a lifetime appointment, and it's not a competitive election. It's in between ground, is that correct?
That's correct.
So describe briefly how merit selection works, and then I'll ask you to talk about how merit retention works.
Well, I think, let me say in the beginning, I think I'm probably one of the few people that has experienced all different types of judicial election processes. Because as a very young circuit judge, when I was appointed, it was a clear political process that you had to qualify in the Democratic primary and win a Democratic primary, and then you were subject to the general election. And then it changed from there to a nonpartisan election, but still a competitive election. And then Governor Askew, as part of his individual program to develop merit selection of judges, not merit retention, because he couldn't do that. But in the appointment process, he created the nominating commissions. And he said one thing. He said, I do not want to know their political affiliation. And I know that for a fact because I happen to know the circuit judge that was first appointed by Governor Askew. And he was a lawyer, a very excellent lawyer that tried cases before me as a circuit judge, and was very well respected from Tampa, and was appointed as a circuit judge, even though basically that people said he was a Republican and he was the first merit selection appointee that Rubin made as governor. But then the process was that he had the merit selection, but not the merit retention. So when I say that I experienced all of it, although I was selected on the merit selection, a competitor could still qualify against me. And I had opposition from Miami, who was Governor Kirk's chair on war and crime. And so I had to run a statewide race to keep my job.
This was after you were on the Supreme Court?
On the Supreme Court in 1974. And then it was put on the ballot, and actually Justice Hatchett and Justice Sundberg both had to do the same thing in 1976 when the retention portion was on the ballot. And when in the retention portion of the passed, then from those years on, in other words, from 78 on, it was merit retention for all appellate judges.
Now you've...
And then I had 3 merit retention elections. So I can say I've started with a real true political competitive election and ended with a merit selection election.
So you're in a position to know the relative pluses and minuses of each type of
Very much so.
selection.
Because both from the inside and the outside.
So in your opinion, in your knowledgeable opinion, which is preferable?
Well, the one thing in a competitive election, if you have a competitive, there's 2 key factors of a competitive election. Number 1 is name identification. Number 2 is funding, finances. And at that particular time, when it came on in, if somebody was running for a circuit judge in Miami, they had to raise $500,000. Now, in the process of where does the money come from, one of the things that occurred was that there's few little things that judges can do, but they can appoint attorneys to represent individuals. And we did notice during my tenure on the Supreme Court, and we had complaints about it from county officials, about the high amounts of fees awarded to attorneys who were representing defendants in conflict cases. That was never brought into being as far as what you would call a court case or a discipline matter. The other that I can tell you that when serving as chief judge, I had judges come and asking me to please change their present assignment, which was either on civil or maybe probate, or, well, it wasn't probate, or juvenile, to criminal, because that's where their name would be in the newspaper every week. So it's basically the process shouldn't be influenced, or what you do or how you do it, by that part of the political process. At one stage, we did a comparison because circuit judges can both be elected or where there's a vacant seat, and they can be appointed if it's midterm through the merit selection process. And we did note that if you categorize them on the discipline aspect, much higher percentage of judges who came onto the bench in the elected process were disciplined than those that came to the bench through the merit selection process.
So merit selection really acted then as a quality filter for judicial...
Very much so.
For judges.
And you shouldn't be limited by the fact that there's no reason to apply because you're of the wrong political affiliation, if you're a qualified judge. And I think Governor Askew clearly set that example. He said it, and then he applied it.
Now, when Governor Askew created the merit selection system with judicial nominating commissions, the composition of those commissions was different than it is today. Isn't that correct?
That is correct.
I believe Governor Askew set it up so that there would be essentially nonpartisan, and I believe that changed perhaps about 10 years ago.
Well, it changed in the context of it. You had 3 appointees that came from the bar, and then you did have a requirement for non-lawyer appointees. And the governor had 3 appointees, and then the commission itself had the authority to appoint 6 others.
So you have equal parts, really. Members chosen by the governor, chosen by the bar, and then chosen by that group.
And they could not, that group could not succeed themselves in the process, so they couldn't build anything on it, and they could not seek a position when they immediately had left it.
A judicial position?
A judicial position.
So this had to be people made, the JNCs had to be made up of people who were not interested in becoming judges themselves.
Well, they could, but 2 years afterwards they could, after they served.
Now the makeup of the JNCs has changed since then, hasn't it?
Well, it's changed to give the governor much greater selection power in who sits on the nominating commission.
Let's talk a little bit about election of judges, and both in new judges and in retaining judges by popular election, since you have you've lived through that yourself as well. You mentioned that money is a problem. For one thing, that the need to raise for a judge who cannot take much of a political position on anything to raise money. Do you see any difficulty in where the campaign money tends to come from?
Well, there's always that. Particularly nowadays, in view of the more recent decisions of the United States Supreme Court, the money can come from entities that clearly have or may have interests before the court and in court proceedings. And one of the things that judges cannot do is participate where they have some type of financial interest. And that goes to multiple things. I can give you an example. You want me to cut that off?
Yeah, that'd be great if we can just silence the...
I want to make sure that wasn't mine. I was like,
It's got to be a child. Yeah. I don't know who it is. And that I'll call it back.
Can I
Sorry.
put your phone on silent for you, or can we get it?
Yeah.
That would be perfect.
Yeah.
Because you're very popular today, apparently, so...
Well, I got a child that's coming in, and that's who I thought it was.
Okay. Yeah, those cases make those button a little bit difficult to get to
I kept
sometimes.
wondering why. Remember when I kept looking over you like it was mine? Well, it's because I'm hearing it in my headphones, and it sounds like it's coming right there. Like, oh no.
You're all good.
All right, now
Okay, let's see.
Okay, sorry.
Where were we?
I had some.
Financial conflict of interest, I think you were talking about.
I think one of the things, I'll give you one personal thing, and that was the fact that my wife had inherited some money from her mother's estate, and she wanted to invest it in Disney. I said, you can't. And she said, why not? I said, because we have 3 cases pending before the court involving Disney. But the other thing, Justice Ehrlich, when he came on the bench, had a significant number of shares of Barnett Bank stock. And the rules don't require him to sell the stock. It just says you're not supposed to acquire anything more that's going to require you to disqualify yourself. But he would disqualify himself from all Barnett Bank cases, as did Justice Grimes, for another reason, and that because he had a child that was the branch manager of one of the largest branches of Barnett Bank. So whenever Barnett was involved, we were basically down to from 7 to 5 justices. The other thing that judges disqualify themselves is when their children are involved as lawyers even though they're not arguing a case, but in a firm that has cases before the court. Both Justice McDonald and excused himself regularly. I know Justice Perriente does, as far as with her son that has had different positions in West Palm Beach. But those are examples of what judges have to do and to what be careful of, to not have anybody or anything involved where they have a financial interest or involves a family member.
So what's a judge to do when a judge, as trial judges still do, has to get reelected and finance a campaign with donations from someone? Does that put a judge in ethical difficulty?
Well, it does in multiple ways. It can be both before and after. There's an example that I like to say. I said, we really don't want Texas justice in Florida. And the example is the Pennzoil case, where Texaco objected and appealed because attorneys for Pennzoil had made a $10,000 contribution to the trial judge that ruled in their favor. It went on appeal, and Texaco said, well, I guess we've got to do something ourselves, and made $75,000 in contributions to the members of the Supreme Court, most of whom were running at that time for re-election. However, they ended up to be outbid because Pennzoil gave $300,000+ to all the justices on the Supreme Court, including those that were not up for election. Now, that's not the type of thing that you want to get involved with. It's not, and it's not just that, just the money situation. It's the fact as to whether or not they can really influence a decision. You don't want any type of outside influence to come forth in the justice system. And that goes right back to what the founding fathers said, is the fact that they should not be subject to a competitive election.
Thank you. Now, in merit selection, though, isn't that less democratic than electing a judge? Doesn't that remove selecting a judge from the people who the judge serves?
Well, in many instances, what you have is you do have the open seats where anybody can run for election if they qualify. On the other hand, a lot of them start their judicial careers, which is a leg up by being appointed by a governor. And if there's no merit selection in that process, then the politics takes place.
How many people typically run for judge in an election versus how many apply in a selective opening?
Well, it kind of it depends, because the governor is not going to appoint ordinarily when a vacancy occurs 6 months before the election. And in the other elections that are always open are those that occur when a judge finishes out his or her term and it's going to be a vacant seat. It's not a vacant seat until he leaves the bench. It is a vacant seat for somebody to qualify for that particular seat. And see, you have judges that reach the magical age of 70, which is what some people have called constitutional senility, where it's mandated that they retire.
Do you feel that the public, I'd like to talk about the fact that in a judicial election, there are typically how many candidates for an open seat? 2 or 3?
It depends. There probably are more candidates competitively in the lower East Coast than there are in North Florida.
Mm-hmm. When a seat is open for merit selection, can you tell me about how many applicants typically might apply for one of those?
I think one of the things that you have to make sure to make merit selection work is to not have an impression that they have no chance at all, no matter how good their qualifications are. Because, for instance, they're not of the right political party. Mm-hmm. And that's one of the biggest single things that can occur, that you have qualified people that won't apply.
Do you think that happens now?
Oh, I have no question about it. I think it does.
And so do you believe that there's actually a widespread belief now among would-be applicants that if they are not of the right political party, their chances with a JNC are no good?
Well, even if they happen to be one of the three or within 6, they can send up 3 to 6 names. There isn't any likelihood that they're going to be appointed if they're a Democrat. Okay. So they don't go through, and let me say the application form and everything and what they have to do and the financial disclosure they have to go through is pretty substantial. And if they feel they don't have any kind of a fair chance, they're not going to apply.
Do you believe that changes for the better or for the worse?
Well, there's no question that I think that a fair merit selection system is important, and really the merit selection system that was created by Governor Askew. He really made it and emphasized that he did not want to know political affiliation. He wanted to know qualifications of individuals. And while I was a circuit judge, I knew, because I was chair, he did call me in some instances. Sometimes I didn't like it because I didn't like to say something, but he was concerned about the qualifications of individuals and lawyers, that they would make a good judge. And Governor Collins had said also, as did Governor Askew, that one of the most important appointments they make are those of the judges, because those are going to be there for a substantial period of time after they leave office.
True. Now, another thing that has changed in the more than 30 years that merit retention has been in place is the advent of super PACs and the ability for independent groups to raise large amounts of money anonymously and have an attempt to have some influence on judicial retention. Do you have any thoughts about the organized opposition to the justices that are up for merit retention this year in 2012?
Well, the opposition by the Republican Party on the basis of one case, the Nixon case, is not justified at all. I happen to be one of the justices on the Nixon case when it originally came to the court. I know the case. But I also know one other thing. The issue involved in this was whether or not it was effective assistance of counsel, where counsel in the Nixon case conceded the guilt of the defendant without his consent. Florida has been very sensitive to the matter of the rights of a defendant because the two cases of the United States Supreme Court that required effective assistance of counsel, the one, Gideon, in felony cases,
Gideon v. Wainwright.
and the second one, and I'm trying to think of the name of the sheriff in Leon County, that required legal counsel if jail time was going to be imposed in misdemeanor cases, came from Florida. So basically, the Florida Supreme Court has been very sensitive to the effective assistance of counsel, and particularly in death penalty cases, because there has been questions about whether they, first of all, to begin with, on providing counsel for post-conviction relief proceedings. And I think that's one of the reasons why the majority did what they did. I guess I can say that they got hit pretty hard previously, and they said,
Let's
so
not
that-
make that mistake again.
yes.
Now,
So-
Justice, how
It's
many-
it's a it's a really close legal issue in that particular instance because of the circumstances of the facts of that case, and the fact that Nixon was very disruptive, which was the new thing in that particular era, and when that case was tried, and what counsel does and what counsel can do and what counsel cannot do. And in this particular instance, what the court said, well, you could do everything else, but you can't concede that he's guilty without his consent.
do you think they were surprised that they got reversed?
Probably, but it's a legal issue because of the defendant's conduct during the course of it. And I can argue pretty well both sides of that particular case, but it's not a clear case and it has nothing to do with the death penalty itself.
And Justice, you served on the Supreme Court for 25 years?
24.
24. Can you estimate about how many cases you have to decide in a given year?
Under ordinary circumstances, we were, during the time I was there, that each of us had to really write between 50 and 60 majority opinions.
That's per justice.
Per justice.
Times 7.
And publishable opinions over right at 400, 350 to 400. And to put it in comparison with the United States Supreme Court, this last year they only rendered 65 opinions. Now that's a little bit different from Justice Berger's time because he used to be they would render between 150 and 175 cases.
So 350 to 400 cases a year.
Published opinions.
Published opinions in a year.
That's not cases that you heard. That's not cases. There are basically two functions that the court has. One function to begin with is whether it's a case that you have to take. There are a very limited number of cases that the Supreme Court of Florida has to take, one of which are death penalty cases. And those are death penalty cases where the death penalty is in fact imposed. They do not take cases where the death penalty is not, unless there's some other legal issue involved. And the other is where a statute is declared unconstitutional. If a statute is declared unconstitutional, it's mandatory that the Supreme Court of Florida review it, like to say it's a matter of death and constitutionality are the two primary issues that the Supreme Court of Florida has to decide, and that's one of their big primary functions. Now, I'll tell you a story about on the constitutionality of statutes. We had a case that came on up that we had taken, the District Court of Appeal had certified the question to us, but it had a constitutional issue involved with it. They did not declare the statute unconstitutional, so it was discretionary whether we take it or not. But the court took the case and was hearing oral argument. The lawyer went on and explained in depth how bad this law was, and that it should be declared in just all the points in that regard. And finally, after 15 minutes, the justice said, "This is Justice McDonald. Counsel, you told us how bad this law is and how dumb it is. You have yet to tell us why it's unconstitutional." And then he said, "We see a lot of dumb laws, but that doesn't make it unconstitutional."
And
so that, and the other thing that is a principle that it's long-standing, it probably came a little bit in the forefront in the healthcare case before the United States Supreme Court. The principle that courts have, as far as the law is concerned, on a statute, is there's a presumption that goes with it that it was correctly and constitutionally adopted. That if there are provisions in the statute that make it unconstitutional, the court does have the authority to delete or modify it as long as it does not change the major intent of the statute. And that's really what Justice Roberts did in the healthcare case. That to the extent that you can approve a statute by restrictively construing it in a manner in how it's applied, you're required to do that. It's not what you like or what you don't like. And I think one of the things, and I've written about it, that I like to say as an example, judges ruling on matters on the law and not on their personal views, are two death penalty cases in which the two judges that imposed the death penalty said that under the law, they must, and to make the law consistent, so under the same facts, people aren't treated differently, they had to impose a death penalty. But then they both went on in their opinions in two different cases, saying why they totally disagreed with the death penalty and why they did not think it was really beneficial to the justice system in this present day. But they still imposed the death penalty. And I think that illustrates the fact that what judges have to do is apply the law. And I learned one issue very early on as a circuit judge. I had a highly contested custody case involving two young boys. And I ruled on it. One of the things I was requiring the parents to come in every 30 days for the next 6 months, give me a status report of what was going on. But anyways, one of the lawyers afterwards stuck his head in my door and he said, "Judge, you must have been right. They're both mad at you." Now, the point is that when you sit in that position, you're not in a position to make people happy or agree with you. In fact, it's seldom you can make both sides happy at all, and particularly in the domestic relation area. But it's a totally different type of process that it is for a member of the legislature or for the executive branch.
Because they're elected for the purpose of being political, for bringing forward a political agenda.
Well, that's correct. They have that's, part of their job is to render what their constituents want. But as far as the independence of the judiciary, which Hamilton very vigorously explained, was to protect the individual rights of the minority. And it basically saying the majority can take care of itself. But what the judiciary has to do is to make sure to protect the individual rights of the minority.
In your experience, in your 34 years on the bench total, have you seen judges actually making decisions based on their personal political preferences?
Well, I was fortunate to be in a judicial circuit where I don't think that was done. That's not to say it was not done in other areas of the state. We were leaders, and I'm not saying because I was there, in a number of ways. It was kind of interesting that the Democratic sheriff and the Republican prosecutor got along very well. It was one of the first areas in this state to do pretrial intervention. One of the first areas of the state, and I'm talking about in the 1970s, to do guardian ad litems. And everybody has to cooperate in that particular process to make the justice system work better for the parties that are before it in those particular matters. The pretrial intervention was as far as both the prosecutor, the public defender, and the sheriff recognized that it was costing them a lot of money on going through a trial that they knew somebody was going to end up on probation. Mm-hmm. And if they could do the pretrial intervention program, it saved the county a substantial amount of money and probably made it much more beneficial and much more satisfactory from the standpoint of recidivism on taking care of those particular people that you thought that you could control, but where they would not repeat their offenses.
It's interesting. Now, if I can bring us back a little bit to merit selection and retention. One thing that One thing that you have written about that I'd like you to talk about here, if you'd like to, is a way. It's a way in which merit retention is actually makes a judge more accountable to the people than an elective or a re-election. Can you talk about that a little bit? Describe how that works, because I know it wasn't.
Well, if you know that you're going to be, you're always going to be on the ballot
at the end of every term.
At the end of every term, if you've got enough political clout that you think you can do anything you want to, it makes a difference. Because then at the end of your term, you don't have to worry because you're unopposed.
So, so if you're if you're a judge up for re-election, as circuit and county judges are, if no one opposes them, do they even appear on the ballot?
No,
No. So a
and
judge
I've had that experience.
So a judge in the elective system could go along never, ever having a challenge in his or her career, correct?
Correct.
And so the public, in fact, could be ill-served by that judge, but that judge has political clout.
Well, from a political standpoint, if you're looking at, for a judge, it's not just the election process for which he could be removed. He can be removed from office by the Judicial Qualifications Commission, and they have done that. And it doesn't require a felony conviction. Doesn't require an offense where if you were a legislature, the governor could suspend, or a state officer. Where the justice system has been compromised in some way, and he can be removed from that. And the legislature also has a say because they're still judges are subject to impeachment. So that the check on that is much greater than it is for any other public official.
And in merit retention, it's even greater because every 6 years
They're up for election.
they're up for retention.
Retention.
Plus there's the JQC and impeachment.
Well, and in the merit retention, they know that, for instance, the Florida Bar and the lawyers are going to vote on your how you conducted yourself during the course of the prior 6 years. That is going to be published.
For all the hundreds of cases
Correct.
that you have had a hand in deciding over the course of 6 years.
Yes.
Not just one or two high-profile cases, but hundreds of cases.
That is correct.
Is there anything else you'd like to add on the subject of merit retention or selection?
Well, I don't think there's any question about the fact that you get higher quality individuals from a true merit selection process as well as the merit retention process.
Thank you. Now, if we could move along a little bit, I'd like to ask you just a few questions going way back to the, again, to the 70s, and ask you about the original revision of Article 5, the judicial article to the Florida Constitution. And as you know, the Constitution revision was adopted, the whole Constitution was revised and adopted in 1968 except for Article 5. You were the chair of the Conference of Circuit Judges in 1972 when the judicial article was adopted, was put on the ballot and adopted by the public by an overwhelmingly positive vote. What I'd like to ask you about that is, what was it about the 1972 article that got the circuit judges' support when earlier efforts had not gotten their support?
Oh, I think they recognized that the growth of Florida required that you could not continue to operate like we were. For instance, in Pinellas County, and in many counties, you had multiple courts that were individually set on up. Some had civil and criminal court of records that were combined. Some had just a civil court of record. Some had just a criminal court of record. Juvenile courts were set up individually, and if not, then with the county court and the county court judges having the jurisdiction. You had a magistrate system, and for instance, in Pinellas County, where I came from, there were 5 magistrates that heard the small cases from within their particular jurisdiction, together with a county court that took what amounted to be cases that they could sentence individuals to the county jail, and then each of 29 cities had separate municipal courts. Now, basically in Pinellas County, what it ended on up is the consolidation of a circuit court, a county court, a two-tier system, and all the municipal courts were abolished and all the magistrate courts were abolished. There was the concern about, I think, some of the more senior colleagues of the circuit judges that they did not like the fact that juvenile judges and probate judge jurisdiction was coming into the circuit bench.
Why not?
Well, I shouldn't say just those two, and criminal felony cases in almost every metropolitan area in the state except Pinellas. The felony jurisdiction was in a separate criminal court of record. And they kind of like what they had that they did not have to have the responsibility of any criminal matters except the fact of capital cases.
So it almost sounds as though they wanted to keep a little bit of specialization at the circuit level, maybe?
Well, it wasn't so much specialization because there wasn't that much, as far as you were either on civil, you just had your civil cases, both equity and in law and domestic relations. And what came into the circuit court, which it should have, was the guardianships and estates, juvenile, which it should have, with dependency matters, and how those are to be absorbed into what it was to be considered. And we had, you had judges that were county judges that were doing nothing but probate, and they didn't like the fact that they could be required to do other things. I had one chief judge that depended on who was to serve in what division. He said it was he had his parking lot theory, that he would go out in the parking lot at 3:30 to 4 in the afternoon and see what judges' cars were no longer there, to find out that who really had the caseload and who didn't have the caseload.
Interesting.
To balance off, and the rotation of judges was the big thing of bringing them into different particular areas where it was necessary.
Well, so it was clear in '72 that an overhaul needed to be done, but 2 years earlier in 1970, the Conference of Circuit Judges opposed the revision, the attempt at revising Article 5 that went to the ballot in 1970 and failed. What was the difference between those two?
Oh, I think it was the fact that the judges recognized they had to do something about the system.
So in 1970, they just weren't quite desperate yet?
Well, let me say this. Adjusting to growth, it just wasn't going to be like it was. And I'll give you an example. During my time as chief judge in Pinellas County, we were averaging 3,600 new permanent residents a month. Now, when you start putting that into, it affects everything that you're doing and how you're doing it and just being able to try to keep up with what is there. The other was the substantial increase in both criminal matters and how to keep up with the criminal matters, and also because of all the changes that occurred in the 60s and early 70s in criminal requirements. And you just didn't have the manpower to take care of it. And I think there was a true recognition that we had to get a system that really worked.
Did you play an active role in I believe in 1972, you were heading up the cooperation of the circuit judges with the Article 5 revision. How about in 1970? Did you have any role in trying or not trying to get that ultimately unsuccessful Article 5 through?
I wasn't really in the loop at that stage. I came into the loop later. As chair-elect, you end up to be the legislative liaison. And we did, I think there was a recognition by some of the older judges that had opposed it, that something really had to be done.
Okay, thank you. That helps me understand a little bit better. Justice, do you have any other things that you would like to add?
Oh, I think you've got enough out of me.
All right. Well, I thank you very much for taking the time to talk with us today for the Historical Society, and I appreciate it.
Well, let me say something about the Historical Society.
Yes.
Because, of course, I was there. It was during my tenure as Chief Justice that we created the Historical Society.
I didn't realize that.
And my wife was very much interested in it, had been all the way along the line interested in making sure that the history of the court was maintained. I made some comments at my retirement about it, one of which was I was going to have lunch with my wife, and I said, I've got to go over and look at the Whitfield building, which was being considered to be restored for the First District Court of Appeal, with the engineers. And I said, I need to go there, and then we can go to lunch. You want to go over there with me? So she went with me. In the Whitfield building is where the PSC was. They had already vacated it. The Whitfield building was the old Supreme Court. And it was the Supreme Court after they moved from the Capitol to the Whitfield building. And
before the present building.
Before the present building was built. And before the new Capitol was, the old Capitol was restored. And the engineers said, and really some of the district really thought from a historical purpose, if it could be restored, they wanted the First District there. Well, we found out from the engineers that they said the floors were cracked, they just couldn't do anything. They could probably save the walls and that would be it, nothing else. And it would have cost more than building new buildings. And then we went on and we were in the kind of the courtroom, which the PSC used. It was kind of in disarray, but the bench was there and it had a wooden carved seal of the Supreme Court of Florida that was kind of chipped. And but my wife asked the question. She said, well, what's going to happen to this furniture and furnishings here? And the Department of Administration said, oh, it'll be cut up and salvaged. So my wife said, you have to stop that. That's all she said. And I called Governor Askew, and I told him, I said, we want to maintain that. I've got a hearing room downstairs that we can put it in for now, but if we're going to restore the old Capitol, that bench ought to go up where it was. Now, it's been restored, it's there. The furniture that also is there, although the district court took the council tables and the chairs. I think we got them back, from when we restored the court. But in addition, then Governor Askew said, well, he said, I'm moving. He said, can you use the crystal chandelier in my reception area and the two chandeliers in my conference room, because we can't use them. And I said, I didn't know where I was going to put them. I said, yes. Justice England followed me and he said, where are we gonna put the, they called me about the chandeliers and that. So if you go up there, you see the crystal chandelier is in the Chief Justice's conference room right above in the rotunda, just off from the grid. And the two chandeliers from the governor's conference room are the chandeliers in the lawyer's lounge.
Oh, okay. That's great.
So,
That's great. So you're.
and then she served on the board of directors for years.
Oh, that's wonderful.
During the entire time I was there.
Oh, that's great. I didn't realize that. That's wonderful.
Yeah. It's in the, you'll see my comments concerning that in my retirement remarks from the court on the matter of that. But she saves, she had a very strong belief in keeping history, and there's one of the things that we've been trying to, we weren't successful about. There are, I shouldn't say were, but there are 7 rockers with writing, a big writing plan on the right side. You weren't supposed to be left-handed like I am.
Like I am, too.
One in each justice's chair. Ann Booth has one. Johnson, the former executive editor of Tallahassee Democrat, has one. And Terrell's family has one. I don't know where the other ones are.
I need to get one.
Huh?
I need to get one.
Well, we wanted to get them for the Supreme Court, to get them back for the Supreme Court is what she wanted to do. But those were the two, the things we weren't able to accomplish, let's put it that way.
That sounds like a good project for the society. Great. Thank you so much, Justice
Okay.
Overton.